Hello, I'm William Clayton. I am a trial lawyer in the state of Florida, and I had the privilege of going to the Paul Rogers Federal Courthouse on September 1 at 1 o'clock to hear the issue of whether or not in Department of Justice versus Trump, the court should appoint a special master to review the documents seized at Mar-a-Lago. At the beginning of the hearing, the judge said that she'd give each side 10 minutes and then ask questions. In fact, the case lasted an hour and a half, and both sides had a full and fair opportunity to say anything and everything they wanted to. The courtroom was packed, and the judge rotated from one side to the other, asking questions. The judge was clearly prepared. DOJ's lead prosecutor, Jay Bratt, was not shy and said there was evidence of 3 significant federal crimes. Department of Justice also said that former President Trump was unlawfully in possession of government records. The picture of classified documents spread across a floor, a carpeted floor, speaks volumes. If a picture could say 1,000 words, this may say thousands. Trump's attorneys were first able to present and argue on the motion. Christopher Kise, on behalf of the former president, said that the issue of a special master was important because he claimed there was a perception of a lack of transparency at the Department of Justice. Mr. Kise said former President Trump was not some Defense Department staffer who stuffed documents in bags and then left. Mr. Kise tried to appeal to the politics side of it and said that a special master would give the American people confidence in the government's investigation. Mr. Trump's second attorney up, James Trusty, took the position that the issue of appointing a special master was a modest idea. Not really. It's novel, in fact. Mr. Trump's attorney, Trusty, claimed that the raid on Mar-a-Lago was a colonial time seizure. Mr. Trump's attorney took the position that basically all of these records and the National Archives having them back were something like Mr. Trump having books that were overdue to go back to the National Archives library. Not quite, right? The judge at some point said that there has never been a seizure like this before of a former president. Counsel for Mr. Trump said that they should be able to review the documents themselves. Department of Justice, on the other hand, took the position and said that no special master should be appointed because, in essence, the horse was already out of the barn. The government already had all the documents. And since these were the government documents anyway, Mr. Trump had no right to them and no right to review them now to get a preview of the government's criminal case against Mr. Trump. Ms. Adelstein said that the documents seized were the most classified documents of the United States. In a criticism of Mr. Trump's position, Judge Cannon challenged Mr. Trump's counsel, saying, "Why did you wait 14 days to file this motion?" Judges love the concept of waiver, or to put it another way, Mr. Trump's lawyers sat too long on Mr. Trump's rights to complain. The judge indicates she was concerned about leaks in the media about the case. Judges don't like cases tried in the media or leaked to the press. The judge, after the hearing, said she would take it under advisement and she would issue a written order, which we expect soon. Thank you.